Welcome to Solving Citizen Legal Encounters. All right, today we're on the record with a pro se defendant who wants to represent himself on a felony case. But that's not the worst of it. The bad part for him is he's in Judge Simpson's court. So let's go in, check out the hearing, and see how it works out for him. And before we go into this hearing, I want to welcome a new member. Phil, welcome to the membership. Check out the community post. It's something over there for you. Let's go.
Case of the people of the state of Michigan versus Cody Jolly.
Andrew Childers appearing on behalf of the people.
Mr. Jolly, today, are you gonna state your name for the record?
Yeah, Cody Lee Jolly.
All right, thank you. All right, Mr. Jolly, this is the date and time set for your preliminary examination, what we had set before. And since you're representing yourself at this preliminary examination, I'm going to once again apprise you that you are before the court on charges that allege that on or about August 10th of 2024 at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, state of Michigan, that you did make an assault on a prison employee or employment or an employee of a place of confinement. You understand that charge, sir?
No, could you say more? Yeah, I understand, but I got the discovery here. I couldn't hear you there.
Okay. That is a felony punishable by up to 5 years incarceration, $2,500 fine plus court costs. You understand the maximum penalty, sir?
Yes, I do.
All right. And you're electing still to represent yourself?
Yes, I am.
All right. There's great peril in representing yourself. You need to be aware of that. The court won't treat you any better, won't treat you any worse by you representing yourself. I would further advise you that if at any point you wish to be represented by an attorney, then you should let the court know at that point. And I will do my best to arrange that you have an attorney to represent you. You understand that, sir?
I do understand.
Okay. All right. Are we ready to proceed?
Your Honor, the people are ready to proceed with their preliminary examination, and I did hear Mr. Jolly acknowledge on the record that he does have the police report now that was served, I believe, Thursday night or Friday by jail staff, and I provided the court with a copy of the proof of service. The people are ready to proceed. We intend on calling one witness when the court is ready.
All right, very good. And I do have the proof of service in the file, and you may proceed then, Mr. Tillman.
Thank you, Your Honor. The people would call Officer John Apple to the stand.
Sir, please come forward to be sworn.
You solemnly swear or affirm the testimony you're about to give me the truth and nothing but the truth, so help you God.
Yes, I do.
Have a seat, state, and then spell out your name.
Hello, I'm Officer John Apple, JOHN.
All right, you may inquire.
Thank you, Your Honor. Sir, how are you currently employed?
I work at the Washtenaw County Sheriff's Office and their corrections division.
And how long have you worked in the corrections division of the Washtenaw County Sheriff's Office?
Approximately 18 months.
Okay. Were you working in that capacity of August of last year, 2024, specifically August 10th?
Yes.
Okay. And you were working in the Washtenaw County Jail? Your shift on that time, on that day?
I believe it was noon shift. It was 3 o'clock to 11.
3 p.m. to 11 p.m.? Okay. Directing your attention to around 5 o'clock in the afternoon or early evening on August the 10th, 2024, what were your job duties in the Washtenaw County Jail at that time? What were you doing?
I believe at that time we were doing our meal pass, make sure everyone gets dinner for the night. In the specific housing we were at, it was a door-to-door feeding unit. So you work with a incarcerated individual, worker, or trustee. You go door-to-door to meal pass.
Okay. And what specific block or area of the jail were you working at that
I was
time?
working at A block that also has our max housing unit and observation unit.
So it has max housing observation unit, and that is within the A block of the jail.
Correct.
Okay. And you said you were passing out dinner effectively?
Correct.
Okay. Are you familiar with an inmate by the name of Cody Jolly?
I am, sir.
Was that individual housed on that block at that time?
He was.
Okay. I don't know, Your Honor, is the screen that in front of Officer Apple the same screen that we're seeing, or is that screen black?
Should be this.
Okay.
Well, no, he is, yes, he is seeing what we're, I guess, primarily that, the one that's moving.
Okay.
is the one that he's seeing. Right?
Officer Apple, can you identify anyone on the screen in front of you that you recognize from that date of August 10th, 2024?
I can't, sir. I see a cursor individual, Cody John.
Okay. And can you describe what they're wearing on the screen so we know who you're talking about?
Orange pants and a white long sleeve t-shirt.
Thank you. Your Honor, may the record reflect identification of defendant Cody Jolly.
Record shall so reflect without objection.
So Mr. Jolly was housed on A block and that's where you were passing out meals on August the 10th of 2024?
Yes, sir.
Okay. What, if anything, occurred when you had an interaction with Mr. Jolly on that date and time?
When I approached his door and breached his door to pass him his dinner for the night, he asked me if he could have another tray. He was sitting on his bed in the unit at the time. I told him that, if I have any extras, I'll circle back to him. And when I turned to collect a beverage for him, he began to stand up, and I believed that he was coming to approach me to grab his drink. But at that point in time, he began to strike me in my head and face area. We got in a bit of a scuffle. I tried to gain control of Mr. Jolly. He kept delivering strikes to me. So I delivered strikes back in self-defense. Was able to gain control of Mr. Jolly to the point where I could get back to my radio and essentially call for backup. In the jail, we called an available officer call.
Okay. And I'm going to just unpack that a little bit, Officer Apple. So you passed Mr. Jolly his tray of food, and then you had turned to retrieve the beverage from the cart. And where was that cart located?
It was just off to my right, so it was almost right in front of his door. I had an inmate worker helping me pass trays at the time, so I turned to him to get the cut. And as I faced Mr. Jolly, he began to stand up. Like I said, I believe he was coming to meet me halfway for the beverage, and he began to strike me.
Okay. Other than yourself and the inmate who was assisting you, were there any other corrections officers in that area at that time?
No, sir.
Okay. Did Mr. Jolly say anything to you as he stood up and began, I guess, to kind of advance towards you?
No, sir.
Okay. You said he struck you in your face.
Right.
Do you have any idea approximately how many times?
3 to 4 times.
Okay. Do you recall, was that closed fist, open fist, slap? Can you give us any detail?
Close fit. So it was kind of towards the top left side of my head and my face.
And
Knocked my glasses off.
I'm assuming if he was able to walk around like that, he was in a low level in the jail. I would hope after that incident, they raised the security level so he won't have the ability to run around and assault staff.
Okay. So kind of, you said left side of your head, above your eye. Is that a yes?
Yes, sir.
Thank you. After he struck you a few times, you were able to basically strike him back in self-defense and eventually get control over Mr. Jolly. Is that fair to say?
Yes, sir.
Okay. Did other jail staff respond to assist?
Once I got control of Mr. Jolly and was able to get back to my radio, during the scuffle, I got knocked off as well as my glasses. So I was on top of Mr. Jolly at the time, was able to recover my radio and get that call out, and then other officers did respond.
Okay. Did you suffer any sort of injuries from this?
Superficial injuries, bruising, soreness, no long-term surgical. And I did get sent out to St. Joe's at the time, or the Trinity Health emergency room, and then I had to do a follow-up, make sure I didn't have a concussion or anything before I could return to work.
Okay. And just so we're clear, the Washtenaw County Jail, is that located? I can never get this right. Is that technically in the city of Ann Arbor? No, Pittsfield Township. Okay. In Washtenaw County. Thank you. I have no further questions. Sean.
All right. Okay, Mr. Jolly, do you have any questions for Officer Apple?
No, I do not. Not at this time.
You have no questions?
Not at this time. It's pre-trial right now at this time.
All right.
That's the drawback of being pro se. He doesn't know what he's doing, and any attorney would have asked at least a couple of questions, even if they wasn't going to get anywhere with it.
I have no redirect. I have no further witnesses, and the people would rest.
All right. You may step down, sir. All right. Mr. Jolly, do you have any witnesses that you'd like to call?
I do not, just to remember, this is pre-trial, correct?
Well, it's a preliminary examination, Mr. Jolly.
Okay, all right, I was told it was pre-trial, led to the last court date, and then you told me you were rescheduling it for pre-trial, and so I don't know where we're at in the process. It was my understanding these last two have been pre-trial.
No, they were PCC and then your preliminary examination, sir. And today is your preliminary examination.
Okay, so okay, so what is my next one then?
Well, I don't know yet.
Okay.
Do you have any witnesses that you want to call today?
No, I do not, I just, my.
Okay. Do
my
I have a
question was
motion?
that- So, Your Honor, my question was that it's been over a year and I'm just trying to get to pre-trial. And my understanding was these last two cases were both pre-trial, it's been over a year. And for some reason, we still haven't got to pre-trial yet. Can I ask you why?
Well, I can tell you that you had a competency evaluation that there was an issue with you participating in. And then there was always the issue of your participating in all of the proceedings as they were set. So the matter could not move until there was a motion that was filed by the people, given your reluctance to participate.
Okay, well, that motion was.
So Mr. Jolly, I'm not going to sit there and argue with you. I'm here now with your preliminary examination. You don't have any witnesses. Do I have a motion from the people?
Yes, Your Honor, at this time, people would move to bind the defendant over as charged on the one count before the court.
Mr. Jolly, do you have a response to that?
I didn't hear him. Could you say that one more time?
Pardon?
I didn't hear what he had said.
Your Honor, the people would move to bind the defendant over on the one count before the court and ask this matter proceed to circuit court for further proceedings.
Do you have a response, Mr. Jolly?
So, okay, my response is to move it to circuit court. We're talking about conference then. Is that correct?
Pardon?
Or if we move it over to circuit court, then we're on to conference. Is that correct?
On to conference?
I don't know what conference he's talking about either.
Is that, yeah, he just said move it to circuit. Does that mean we're on to conference? That was my understanding, was that we're moving to conference. That would also be my request too.
Well, I don't know what you're trying to say. All I know is that what the people have asked is that the matter be bound over to circuit court for you to stand trial there.
Right, which would be moving from here to conference, which is right before trial, correct?
You would have different proceedings before Judge Slay, yes.
Which would probably be conference, am I correct?
Did pro se's come up with their own script?
Sir, you will have different proceedings before Judge Slay.
Okay.
Do you have anything in response to the people's motion to bind over?
You know, I would prefer, my response is to prefer to move on to conference. That would be my response to that. And then I also have my own, I would like to request again. I put in the motions for jury trial, a 12-person jury trial. And I also put in my motion for the 45-day speedy trial. I am also requesting those as well again here today. Motions were.
All right. The court has heard the testimony in this case from Officer Apple. The court does believe that the people have indeed sustained their burden of showing that the defendant was in a place of confinement, that he also then assaulted an employee of that place of confinement. And so for those reasons, the court would bind the defendant or find that the people have established probable cause that this offense was committed and that the defendant committed it, and the defendant would be bound over to circuit court to stand trial. Jolly, you're now proceeding into what will be your circuit court arraignment.
Right.
I bound you over to stand trial. I'm now going to conduct your arraignment regarding those proceedings. So I would advise you are before the court on a complaint that alleges that August 10th, 2024, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that being the Washtenaw County Jail, that you did, being a person lawfully imprisoned in the jail, did assault a John Apple, who was an employee of a place of confinement or other custodian, knowing the person to be an employee or custodian through either the use of violence, threats, violence, or dangerous weapons while you were awaiting trial contrary to Michigan statutes. Do you understand what you are charged with, Mr. Jolly?
I understand what I was charged with, yes, I do.
Okay, that is a felony. It is punishable by up to 5 years incarceration and a $250 or $2,500 fine plus court costs. You understand that, sir?
I understand that.
All right. I do also have to advise you that if you are convicted, law enforcement is to collect a DNA identification profile sample before sentencing or disposition if it was not taken at the time of arrest. You understand that, sir?
Yes, I do.
All right. How do you wish to plead to that charge, sir?
No, not guilty. I also.
All right. The defendant, having heard reading of the information, pleading not guilty, court will enter that plea. A pretrial in this matter will be set for
September 25th at 1:30 for Judge Slip.
September 25th, 2025, 1:30 before Judge Slay.
Okay, my request for jury trial, I requested a speedy trial already, and I did file these motions. Now, can you, is this where I bring this up again?
You can bring those up before Judge Slay.
I've already requested it before you, though.
I know.
So
And what I'm indicating is that I am not making a ruling on those because I don't have to. First of all, in regard to any delay in these proceedings, Mr. Jolly, you were the cause of the delay. So I think that any reference you're having towards speedy trial,
there's a right to speedy trial.
it's really your issue. Your issue to a trial by jury is intact. You will have your trial by jury if that's what you wish. Again, you may raise all of these issues before Judge Slay.
I did request a 12-person jury also.
In circuit court, that's the way it rolls.
And so that's the way it goes to the speedy trial. I don't have what you're saying. I don't have a right.
You can raise that if you think that you have been denied that. My ruling is that there has been no violation of any right you have to a speedy trial, because any delay that has occurred in these proceedings is either an acceptable delay in terms of the competency, but also any other delay was a result of your conduct.
It was 30
that
days
delayed
ago
these
on my
proceedings.
request, Your Honor.
Mr. Jolly, I'm not going to sit here and argue with you.
Now he's starting to test the waters just a little bit too much.
I'm telling you what my ruling is. You may raise that issue again if you like before Judge Slay. You will get your jury trial. That will all be set before Judge Slay, and you'll be able to proceed there. At this time, these matters having concluded, your bond is continued. Thank you.
Judge Simpson shut that down fast, because if that guy would have kept talking, he might have encountered another problem. But then again, maybe not, because Judge Simpson knows he's being bound over. So there's no need for him to deal with him again. His caseload is heavy enough. So now we go into the next hearing that I already covered before with a sovereign citizen who was talking about all this tribal stuff and act like he didn't want to get out of jail. The first hearing that I already did, that's already pre-recorded, already had a commentary with it. So we're going to let that ride like I normally do when I put the old ones back up. But then we're going to go into the rest of them so you can kind of keep up what's going on. Let's go. All right, today we have a pop-up sovereign citizen who wants to run the script a different way. You'll see what we're talking about. We're just going to go in and take a look. All right, let's go.
Officer, could you assist Mr. Lafferty in getting into a breakout room, please? Thank you, sir.
All right, so Mr. Lafferty, just hang tight, and then I'll call your case as soon as the court is ready, okay?
All righty. And your last name was what's it? Lafferty, L-A-F-F. Okay, I got you. Thank you, sir.
Mr. Reardon, did you have an opportunity to speak with Mr. Lafferty in private?
I did, Your Honor, and we are prepared to go forward with the arraignment. Thank you.
Thank you. Sir, you are before the court for arraignment. One charge of criminal trespass in the second degree is charged by the city of Lakewood and it would be a criminal complaint 25L004378. Mr. Reardon, how would you like to proceed with the arraignment?
Thank you, Your Honor. I did have a chance to talk to Mr. Lafferty about this charge and his rights at arraignment. I want to enter a plea of not guilty on his behalf. Also, I do believe he qualifies for the public defender, Your Honor. I'm asking for direct appointment to the public defender's office without a promissory note. Thank you, Your Honor.
Thank you. Mr. Lafferty, the court is going to find that there is probable cause to support the filing of the charge. We'll enter a plea.
There isn't.
I will enter.
I may or may not be an arbiter of the law, having attended UC Davis and completed but not received my certificate. And the way that officer proceeded with me was not respectful or within the 24-hour period that had been stated.
Mr. Lafferty,
individuals in the park who took the pictures to make sure that it was unclear. Again, I had been made homeless by 2 officers from my nephew's house.
Mr. Lafferty, I would encourage you not to say anything just for now. The prosecutor is going to talk in just a moment, and then I will talk to you about.
As an indigenous person from California, I'm not sure you have any jurisdiction over me, and I wish that my tribal chairman, Curtis Lachusa from Mesa Grande, was informed that we have our own law and we have our own lawyers.
Huh?
Mr. Lafferty, like I talked about, we can talk about your case, but let's go forward with this for now. And any questions you have going forward, we can talk about it after your hearing, okay?
Fine.
Court is going to enter a plea of not guilty for Mr. Lafferty at this time and is going to waive formal reading of the criminal complaint. Mr. Taninga, what is the prosecution's position concerning pretrial conditions of release?
The city has no objection to the defendant's release on personal recognizance under the conditions the defendant have no contact with Kiwanis Park and the defendant have no criminal law violations during the pendency of this case.
So then you're going to remand me over to being homeless in the state of Washington.
No objection to release on personal recognizance, Your Honor. I believe that's appropriate. Thank you.
Thank you. Court is going to follow the agreed recommendation of the attorneys. The court will release Mr. Lafferty on his personal recognizance. So Mr. Lafferty should be released later on this afternoon.
To be homeless as an indigenous senior citizen.
Court is going to impose a number of pretrial conditions.
I do not recognize those. Then I guess I won't be leaving jail.
Mr. Lafferty, please just hang tight.
Mr. Lafferty needs to appear in person and on time for all scheduled court hearings. His next hearing in this matter will be on August 12th, 2025 at 1 p.m. here at the Lakewood Municipal Court. The court is going to appoint Mr. Reardon to represent Mr. Lafferty.
I do not want Mr. Reardon. I want a tribal representative in charge of me.
Well, and Mr. Lafferty, if you choose to hire a different attorney, that is your prerogative.
That would be up to my tribal chairman and our legal defense team.
But at this point, the court is going to appoint Mr. Reardon.
I do not accept the appointment then.
The court is also going to order that Mr. Lafferty have no criminal law violations, that he update the court of any change in his mailing address, that he have no contact with the Kiwanis Park in the city of Lakewood while this matter is pending. And the court has signed that order.
To be homeless. I'll just stay in
Mr.
jail.
Lafferty should be released later on today.
I refuse to be
Lafferty,
released.
thank you. That will conclude your hearing. You can let the officer know that your hearing is done. Thank you.
You incompetent fool.
As explained in the beginning, he's not saying the standard UCC 1-308, but when he's talking about the tribal land, some sovereign citizens will use that type of script because I've covered them before. Now we're going to go to a second hearing to see how everything plays out here and see what he does in this hearing. Let's go.
Oh,
Good afternoon, sir. What is your name, please?
Raymond Charles Lafferty.
Thank you very much, Mr. Lafferty. And it appears there are 2 matters that are before the court. Mr. Lafferty is before the court under case 25L004378 for a first pretrial conference. He is also before the court under case 25L004397 for an arraignment. He's been charged by the city of Lakewood by criminal complaint in case number ending in 397 with 1 count of criminal trespass in the second degree. This component, beginning first with the arraignment matter, Are you prepared to proceed with the arraignment at this time?
Yes, Your Honor. I had the opportunity to speak with Mr. Lafferty, advise him of his rights, and I believe he understands them. We'll waive a formal reading of the complaint, and we're not contesting probable cause for today's purposes only. I'll ask the court to enter a plea of not guilty, and based on my conversation with Mr. Lafferty, as well as our recent appointment on the pretrial matter, I believe he qualifies for court-appointed counsel without promissory note, so I'd ask the court to make that appointment at this time.
Thank you. Mr. Lafferty, on the new matter for which you are being arraigned, the court is going to enter a plea of not guilty for you, find that there is probable cause to support the filing of the charge, and waive formal reading of the criminal complaint. Court will next hear from Mr. Graham regarding his recommendation on pretrial conditions of release in this matter. Mr. Graham?
Mr. Graham, you're muted.
Thank you. Yes, Your Honor. Mr. Lafferty's history appears to be the totality of the two cases before this court. However, what's most concerning for the city, Your Honor, is Mr. Lafferty was seen by this court on the 17th of July for trespass in the Kiwanis Park. And then yet again, today, Mr. Lafferty is back before the court for trespassing yet again in that same park. Your Honor, the court did order him to stay away from that park, as well as he's been trespassed from that park, yet he has continued to return. And in fact, what concerns the city even more, Your Honor, is when he was, according to the police report, when the officer told him that he wasn't allowed to be in that park, he told the officer he didn't care and he'd continue to do it. Your Honor, the concern the city has is that Mr. Lafferty is not going to obey the order of the court. And so based on that, I do think some bail is necessary. And so the city is requesting he be held on $500 cash or bond on each with no law violations, and reminded yet again to stay away.
It is not posted that that park is ever closed.
Huh?
It is a public park without proper post that says that it closes at any hour.
Thank you, Mr. Graham. Ms. Capone, your response?
Your Honor, we'd ask that Mr. Lafferty be released on his own recognizance. I point out that he's entitled to the presumption of innocence, the presumption of release, and the presumption of least restrictive conditions of release. These being the only matters in Mr. Lafferty's history, they're nonviolent in nature. I don't know that it's appropriate to hold him on any bail at this time. Our request would be that the arraignment matter and the pretrial matter remain on the calendar for the August 12th date that was previously scheduled, and that he remain out of custody. I do think that there may be some concerns or issues with the allegations stemming out of a public forum. Mr. Lafferty and I have spoken at length, and certainly Mr. Lafferty would be afforded a better opportunity to work with counsel if he were out of custody. I'd also point out that he's not working. He has unstable housing, so I don't believe that he'd be able to post any amount of bail. I believe that any amount of bail would be tantamount to a no bail hold of Mr. Lafferty, as he would certainly remain in custody until his next hearing. So we'd ask that he be released on his own recognizance, understanding the nature of the offenses that are charged and the presumptions that Mr. Lafferty is entitled to.
Thank you, Ms. Capone. Mr. Lafferty was before the court last Thursday, July 17th. He's before the court for the arraignment in case number ending in 4378, an identical charge to the new matter that's before the court today. As in that case, in this case, it appears that Mr. Lafferty has gone to the Kiwanis Park in Lakewood where he has been trespassed, and so has entered that park without legal authorization. The court is also concerned that Mr. Lafferty was told specifically by this court last Thursday that he was to not go on upon the property of or have any contact with that park under the conditions of release in case number ending in 4378. And so frankly, the court shares the concern that has been articulated by Mr. Graham. The court is not concerned about violence. The court is not concerned about failure to appear. What the court is concerned about is the administration of justice, which includes Mr. Lafferty demonstrating willingness to abide by and follow all court orders. And he's done the contrary. There's probable cause to believe that upon his release last Thursday, he went back to the Kiwanis Park specifically as this court ordered him not to do, and was arrested for trespassing there yet again. So the court is going to grant the city's request and impose bail in each of these two cases, the amount of $1,000 cash or bond. With that, Ms. Capone, my inclination is to set a in-custody pretrial conference date. Do you want that set for Wednesday or Friday?
Your Honor, given the nature of the allegations, I think that maybe there could be a resolution worked out by Wednesday. So if the court would entertain putting on the Wednesday calendar.
Certainly. So we'll set this for 2 days from now, Wednesday, July 23rd on the Nisqually in custody calendar, which is at 11 a.m. Court is going to appoint the Horwath Losses to represent Mr. Lafferty on case number ending in 397. That is the new matter. They are already the attorney of record on the pretrial conference matter. Court is going to reimpose the same conditions that were imposed last Thursday. Mr. Lafferty is to appear on time for all scheduled court hearings, have no criminal law violations, update the court of any change in his mailing address, not go upon the property, ever have any contact with Kiwanis Park in the city of Lakewood, Washington.
I think you're way out of line. It is not posted.
Mr. Lafferty, I would just hang tight.
I agree. Don't sleep on this, Judge.
Court is going to maintain the out of custody pretrial conference date.
Incompetence, collective incompetence in a kangaroo court.
A sovereign citizen term just popped out.
And that is going to be scheduled for August 12th at 1 p.m. And that is in the event that Mr. Lafferty posts bond and is released from custody.
I will not.
Court has signed those conditions of release. Mr. Lafferty, that will conclude your hearing. You can go ahead and let the officer know that your hearing is done. Thank you. Thank you, sir.
I wish I could say the same.
In previous videos, I talk about how sovereign citizens are so angry, but he can't get everything out that he wants to get out because one, he has the attorney kind of keeping him in check. And two, if he gets to talking too much, that judge is going to mute him. So he's kind of stuck between a rock and a hard place. But if he had the opportunity, I think he would light him up in court. So anyway, we're going to his last hearing and let's see how he acts in here. Let's go.
And good morning in the Nisqually jail. What is your name, please?
Raymond Charles Lafferty.
Thank you, sir. Mr. Lafferty is before the court in two different cases. 25L004378 for a second pretrial conference, 25L004397 for a first pretrial conference. Ms. Ganem, how would you like to proceed with Mr. Lafferty's pretrial conferences at this time?
Your Honor, Mr. Lafferty would like to set this matter or both matters for trial today. We have selected the next, I believe, confirmation date. Additionally, he expressed to me that he would like to try to have somebody contacted through the tribes. He does have contacts in California that can arrange for possible tribal representation here in Washington. I've offered to assist him as best I can, but he's expressed that he feels most comfortable having somebody from a tribe represent him.
Well, that will be interesting because somebody from a tribe coming to represent somebody in state court, are they going to have a state court license? I'm sure they can't roll in there with a tribal license and think that they can represent him in court.
And he has been speaking to that. So in the meantime, he does wish to get this on track for trial to proceed these cases. But there may be an attorney change if he can get that done. He's given me some limited information. I would ask the court to consider releasing him so that he can use his resources to address that issue. If not, he's given me some information that I can go on and I can try to get that ball rolling for him.
All right, so two separate issues that I think are before the court. Number one is setting the matter for the August trial term. Mr. Graham, any objection to setting this matter for trial the week of August 18th, 2025?
No objection for the August trial set, Your Honor.
All right. And
as
the court
to
is
the
reviewing.
form, my only concern is making sure we have the right readiness date depending on how the court rules on his release.
I'm sorry, Mr. Graham, you trailed off there. What was the last thing you said?
The form lists the out of custody readiness date as opposed to the in custody readiness date. So I just call that to the court's attention in case it needs to be adjusted.
Quite right. And that leads me to the second issue. Let me finish going through the pretrial conference form first. Okay. The court has reviewed the pretrial conference form. It does appear to be appropriate. Now, Mr. Graham, I understand Ms. Gannon would be making a motion for modification of conditions of release. I believe bail was previously set in each of these two cases. My understanding is Ms. Gannon is asking the court to reconsider that decision and to release Mr. Lafferty on his personal recognizance in these matters.
Yes, Your Honor, and the city objects to that changing conditions. The reasoning for holding Mr. Lafferty in the first place is that we have two matters that are before the court, both involve criminal trespass. The second of which, both involving the same location, I believe the Kiwanis Park. The reason to hold Mr. Lafferty is that he was told not only by officers but ordered by this court to not return to that park, and yet did so anyway, or at least there are probable cause to believe he did so. So based on that, Your Honor, I don't believe there should be a change in conditions at this time based on his prior behavior in following the orders of the court.
Thank you. Ms. Gannon, your response?
And Your Honor, I mean, I understand the city's position as well as the court's position when they set bail in this matter. Just looking at his background and the nature of this charge itself, I would ask the court to reconsider, especially since this matter is currently set for trial. And he has expressed his concern about his representation, and he does want to reach out. I did explain the possibility that bail would remain, and we'd have to be preparing for this trial while he's in custody. He understands that risk and is willing to go forward and ask the court to set this matter for confirmation and trial and to reconsider bail at this time.
All right. So yeah, I think the recitation from Mr. Graham is accurate. I think the recitation from Ms. Gannon is accurate as well. The concern that the court had was the alleged incident date in case number 4378 is July 16th, 2025. And I'm just taking a look here at the docket to make sure that my dates are correct. Mr. Lafferty appeared before the court in that matter on July 17th for arraignment, and the court released him on his personal recognizance at that time on a number of conditions. One of the conditions being that he not return to go upon the property, ever have any contact with the Kiwanis Park in the city of Lakewood. And then the very next day, he was arrested at the Kiwanis Park and charged again with a additional count of criminal trespass in the second degree. And so at that point, the court was very concerned that he was violating the court's pretrial conditions of release to have no contact with that park, and also, frankly, violating the court's pretrial release condition that he have law-abiding behavior. So, Ms. Gannon, I guess I'm going to kind of turn back to you. Have you had conversations with Mr. Lafferty that lead you to believe that there has been a change in circumstance, that now he better understands exactly what the court is ordering him to do and not do?
Your Honor, I did not have that conversation with him, so I have no opinion on any change besides the fact that he is looking for different counsel.
Okay. Do you want an opportunity to speak with Mr. Lafferty in a breakout room? Because frankly, before the court is going to release him, the court would need some assurance from Mr. Lafferty through you that he is going to comply with the court's pretrial conditions of release? Right now, I see him shaking his head no. So the answer may be that no, he does not intend to comply with the court's pretrial conditions of release. How do you want to handle this, Ms. Gannon? Do you want to speak with him privately?
Yes, very briefly, just to explain a little bit about the court's concerns.
Sure. So, Mr. Lafferty, you're going to be invited to join a breakout room there on the screen. If you could please join that breakout room, that will allow you to speak with Ms. Gannon privately. If you need any assistance getting into that breakout room, you can ask the officer for help.
Officer, I need help.
Well, you can definitely tell he doesn't want to get out of jail. And that's my opinion on why he won't follow the rules. All he has to do is stay away from the park. They release him. He keeps going back to the park. So something else is going on here. But let's get back to the hearing.
Ms. Ganem, do you have any additional information that you would like to share with the court regarding Mr. Lafferty's willingness to abide by the court's pretrial conditions of release?
I do not, Your Honor. He wishes to have bail remain.
All right. Well, and the court does want to note for the record that when I was having that conversation with Ms. Ganem before we went into the breakout room, when I was asking Ms. Ganem about the possibility of Mr. Lafferty indicating a willingness to abide by the court's pretrial conditions of release, I did observe that he was shaking his head in shaking his head no, which leads the court to believe that he does not intend to comply with the court's pretrial conditions. So pursuant to CRLJ 3.2, the court does have a concern that Mr. Lafferty, based on his own assertions, will not comply with the court's pretrial conditions of release. And so the court is going to leave bail as set in this matter at this time. However, the court is going to go ahead and set the matter for trial as requested by the defense. Mr. Graham is absolutely right. The readiness hearing, let me check with the court clerk. When would you like that set, Wendy? Because on the Nisqually calendar on the 14th or on the 13th? Okay, so we're going to go ahead and set that readiness for the Nisqually calendar on August 13th, 11 a.m. Other dates will remain, and the court is going to go ahead and sign that order. We will see Mr. Lafferty back here for readiness hearing on August 13th at 11 a.m. from the Nisqually jail. Mr. Lafferty, that will conclude your hearing. Thank you very much. You can go ahead and let the officer know that you're done.
Those of you who are familiar with my channel knows that I will do checking and looking around on certain things when I present certain videos. So with him, he was living in California, and I think he's new to Washington State. And I feel, in my opinion only, that he may not have anywhere to stay right now. And that's the reason why he's just not trying to get out of jail. I hope you enjoyed these videos. Give it a thumbs up if you did. And I'll follow up with him and anything else I have going on. Thanks for watching. See you next time.